There are many benefits and drawbacks to the law of non-fatal offences and defences. There are also many ways that these laws can be reformed. The advantages and disadvantages of the law on non-fatal offences against the person are that it offers a clear hierarchy of offences allowing proportionate sentencing, but it is outdated, uses archaic language and fails to reflect modern understandings of harm. The law on non-fatal offences against the person is fit for purpose according to some as it provides necessary legal structure, but others argue it no longer meets the needs of a modern justice system. The law on non-fatal offences against the person is up to date according to defenders of the current framework, yet critics argue it relies on Victorian terminology and concepts that do not reflect current medical and social developments. The law on non-fatal offences against the person is just in that it can deliver proportionate punishment, but it is also unjust because unclear statutory definitions often produce inconsistent outcomes. The law on non-fatal offences against the person is effective as it enables the prosecution of offenders, but it is ineffective because its complexity often confuses juries and leads to appeals. The law on non-fatal offences against the person balances principle and policy according to some, yet it frequently prioritizes public policy over individual rights, undermining legal certainty. The law on non-fatal offences against the person is fair in its aim to treat harms equally, but in practice it is unfair as it results in disparities and uncertainty for defendants and victims. The law on non-fatal offences against the person is based on sound moral principles in its attempt to reflect societal views on personal harm, but its foundations are rooted in outdated moral assumptions that may no longer apply. The advantages and disadvantages of the law on intoxication, self-defense, and consent against the person are that they attempt to balance individual autonomy and public protection, but they are inconsistent, complex, and often lead to unpredictable outcomes. The law on intoxication, self-defense, and consent is fit for purpose according to supporters who argue it protects society and sets clear limits on behavior, but critics claim it fails to reflect modern social realities and the complexity of human decision-making. The law on intoxication, self-defense, and consent is up to date in some respects due to statutory developments, but many elements are outdated and rely on Victorian principles that do not align with contemporary societal values. The law on intoxication, self-defense, and consent is just as it seeks to proportionately judge defendants based on their mental state and actions, but it is unjust where rigid rules ignore individual circumstances. The law on intoxication, self-defense, and consent is effective because it provides legal mechanisms to deter harmful conduct, but it is ineffective when its complexity causes confusion and inconsistency in verdicts. The law on intoxication, self-defense, and consent balances principle and policy by attempting to uphold individual rights while maintaining public safety, but it often favors policy concerns at the expense of coherent legal principle. The law on intoxication, self-defense, and consent is fair in that it aims to treat defendants and victims equally, but it is unfair due to disparities in how the legal rules are applied. The law on intoxication, self-defense, and consent is based on sound moral principles in its objective to regulate responsibility and protect bodily integrity, but it is also rooted in outdated moral assumptions that may not reflect modern ethical standards. Ideas for reform on the law of non-fatal offences against the person include replacing the outdated Offences Against the Person Act 1861 with a modern statute using clear language to solve the issue of uncertainty, introducing a tiered structure based on the harm caused rather than archaic offence labels to solve the issue of inconsistency in sentencing, and defining key terms such as grievous and actual bodily harm in statute to solve the issue of reliance on outdated case law. Ideas for reform on the law of intoxication include introducing a consistent statutory definition of voluntary and involuntary intoxication to solve the issue of unpredictability in verdicts, removing the distinction between specific and basic intent offences to solve the issue of confusion for juries, and creating a partial defence for those whose intoxication stems from addiction to solve the issue of unfairness towards vulnerable defendants. Ideas for reform on the law of self-defense include setting a clear statutory test for reasonable force to solve the issue of inconsistent jury interpretation, clarifying the law on preemptive strikes to solve the issue of uncertainty in situations where a threat is imminent, and defining the limits of householder defense to solve the issue of disproportionate force being justified under vague principles. Ideas for reform on the law of consent include introducing a statutory definition of consent that applies across all offences to solve the issue of inconsistency, creating clearer rules around consent in situations involving serious harm to solve the issue of unclear limits on personal autonomy, and establishing a statutory list of circumstances where consent is invalid to solve the issue of uncertainty arising from case-by-case judicial decisions. Thank you for watching this video on evaluation of criminal law. I'll see you in the next one.